Okay, good morning, everybody. Today is Wednesday, February 21st, 2024. This is the South Coast Air Quality Management District Hearing Board. And today we have two items which are on consent calendar, which are AES and Torrance Refinery Company, which we will be taking after we hear California Steel. And so I will go ahead and we're going to take a break until we have all members there, which I'm understanding is just a few minutes. Mr. Perry, did you? Yes.
I feel that we could go ahead and do the motion
Okay.
to allow you to participate.
Okay.
We don't need Makai unless, so.
Right. We've got a quorum.
So,
right.
Hold on, we hear the door.
Yeah, I just there he is. Okay, I'll turn it over to you, Mr. Pearman.
Thank you. So we're going to ask that we vote under AB 2449 to allow participation by the chairwoman under the emergency circumstances exception. And she's making requests and she can elaborate. Does not have to be a lengthy description, does not have to disclose any medical diagnosis or disability condition she doesn't want to disclose, but just to explain briefly why she wants to act remotely today and why the need for this came less than 72 hours before today's meeting. And then once we hear her request, we'll have to vote without her vote being included to allow her to participate. Thank you.
Thank you, Mr. Pearman. The reason I am not there today is under doctor's orders that they don't want me in a vehicle for more than half an hour today and for like the next, not quite a week, probably 4 days until I see them again on Monday. And that's the reason that I'm not there today. So I request that you do allow me to participate.
Thank you. So I'd make a motion that we allow to participate under the emergency circumstances exception of the Brown Act.
Second.
Second. Oh, I think Dr. did second.
Yeah, Ali, just discussion. I just want to make sure that we're in alignment with the law on the amount of times that an individual can utilize the provision.
It's allowed for basically up to 20% of regular meetings. So unlike just cause, it's only twice a year. So she's certainly has not exceeded the 20% of the regular meetings of this calendar year.
Not only that, if I may also speak to that, I also contacted our attorney for the hearing board, Mr. Dale Larson. And the first time that I was at it was, I believe, 2 consecutive days. So they are considering that as one instance. And so I understand what you're referring to, Mr. Ali. So this would even, in fact, just be number 2. Anyway.
Okay, so I just want to be very clear for the record. If any of the board members would like to contact Mr. Larson to inquire of the same circumstance, are we allowed that privilege?
You mean about your own personal circumstance if it arises, you mean?
Yeah, the exact same way that the chair contacted Mr. Larson. I want to just clarify.
You mean if somebody had the similar situation, could they get some clarification from the council how to handle it?
Yes.
Sure. Makes sense to me.
Is that your interpretation, Ms. Verdugo Peralta, that all of us can contact Mr. Larson if we have
But it's a personal item like that and you need it to be, interpretation for that, I would agree with that, as Mr. Pearman just stated.
Let's just make sure Mr. Larson is keenly aware of that. Thank you.
Okay, we have a motion and a second. Any further discussion? If not, could you call the roll?
Mr. Balagopalan?
Yes.
Mr. Ali?
Aye.
Dr. Abraham?
Aye.
And Mr. Pearman?
Aye.
Okay. Thank you very much, board members. I appreciate that. And I also appreciate the discussion for a request for clarification on individuals. So with that, we can go ahead and go to our first item on our agenda. We are, as I mentioned before, taking it out of order as a courtesy to the time frame of the attorneys. And so that will be California Steel Inc., case number 4624-23 in regards to a regular variance. And this is in regards to rules 203, 1146, 2004, and 3002. And with that, who is here on behalf of California Steel?
Olivier Thayard at Shepherd Mullen on behalf of petitioner California Steel.
Harold Parker, Engineering Manager, California Steel.
Okay, Mr. Thayard, can you please spell your name for us, for the clerk?
Absolutely. First name Olivier, last name T like Tom, Heard.
Okay, and you also had another co-counsel?
No, Mr. Parker is a witness.
Okay, all right, so we won't take his name at present. All right, and for the district, on behalf of the executive officer?
Good morning. This is Erica Chavez on behalf of the executive officer.
Okay, good morning, Ms. Chavez. All right. Now, for California Steel, we had some exhibits. And I'll do the exhibits first and then I'll do the swearing in. We have the PowerPoint presentation, which I'm going to mark as number 11. And then we have the proposed findings and decision, which we will mark at number 12. And then we have exhibits, which I know are marked as letters, but they should be numbers. And so I'm not going to mark them in order, but we will be marking. And the question to you, Mr. Thayard, are you going to use these documents and do you want them as evidence or do you want them just as background?
My intent at this time is that those are background materials, but if it becomes necessary, depending on questions, we can refer to them as exhibits.
Well, so you want me to wait until then to mark them? Because normally we mark them at the beginning of the hearing.
I would also be okay marking them. I just may not refer to them and present them to the witness as an exhibit.
Okay,
But they are evidence in the sense that they are part of the petition. So I'd be okay marking them.
all right, let's go ahead then and mark Exhibit B. And that would be actually number 13. Exhibit, let's see. Exhibit C will be 14. And Exhibit D will be 15. And Ms. Chavez, did you have any exhibits?
I don't have any exhibits.
Okay. And will you be having witnesses today, Ms. Chavez?
Not to present, but I have two witnesses, one from engineering and one from compliance, if there are questions from the board.
Okay, and Mr. Thayard?
Yes, I have one witness, Mr. Parker.
Okay. All right. Mr. Parker, if you can please stand and raise your right hand. Okay, and do you swear under penalty of perjury that you will be telling the truth, the whole truth and nothing but the truth?
I do.
Okay, thank you very much, sir. And did you spell your name for the record for the clerk?
It's Harold Parker, Parker.
And your title, sir?
Engineering Manager, which I've held for 28 years.
Thank you, sir. Okay, so with that, we can go ahead and start with opening statements. Mr. Thayard?
Yes. I am putting this back on the screen. Members of the hearing board, thank you.
Make it full screen.
Sure, I'm not sure how to do that. Thank you. technical glitch.
Where'd he go? To the next to the little tab there. That's your little shortcut there. I call it the upside down screen. Sacrilegious. There you go. And then to get out, just escape. Right? I think you pretty, yeah. Yeah.
Thank you. With excellent technical assistance from the wonderful staff at the district. We have the presentation up. So members of the hearing board, thank you for your time today. My name is Olivier Thayard. I am an attorney at Shepherd Mullen, and it's my pleasure to represent California Steel in this petition hearing today. My witness today is Mr. Harold Parker, who's been sworn in. He goes by Hal to his friends. And we are pleased to present information and evidence today to demonstrate why California Steel should be granted a variance. So California Steel seeks a variance to operate its #2 boiler, which is device D252, until it can install, commission, and source test a new burner for that boiler. Variance relief is requested through December 31, 2024. This is different from the petition, which requested until October 31, 2024, and we will explain why that is. The new burner has been ordered. There is a permit application that is due on the 29th of February, according to the agreed upon conditions. It may take, it says 4 to 6 months there, but it may take about 3 months or so, inclusive of the EPA 45-day review period, to receive a permit to operate. The burner itself is expected to be delivered within about 12 to 16 weeks. And after an installation and commissioning process, the facility will conduct a source test under AQMD approved conditions. The reason for seeking time, in addition to what was stated in the petition, is that in very cooperative discussions with district staff and district counsel, Ms. Chavez, the AQMD is requiring that a permit application be submitted for the new burner, having deemed it not to be a replacement or simple modification, but actually require a new permit application for the burner. So given that, it will take some time to prepare the application, but also obviously for the district and its engineers and staff to review it and ultimately, hopefully, issue the permit. And we have to factor in the Environmental Protection Agency has a statutory 45-day review on top of the AQMD process. So that may add some additional time. So in conjunction and discussion with district, we decided to extend the requested relief to December 31. So there are some key facts to consider here. You all have seen us before on variance petitions. So by way of brief background, there are 2 boilers here at issue that California Steel operates. Both of them were brand new boilers with brand new burners. After some time and effort, boiler #1 passed its source test. The requirement for the emission source test is 5 parts per million of NOx. California Steel has taken extensive actions to tune and rejigger, if you will, the boiler #2 to make it pass as well. You all may recall, members of the board, that we were here in July of 2023 seeking variance relief to allow some additional work and commissioning to be done to the boiler to achieve 5 parts per million. You will hear today that California Steel did in fact take numerous actions, from replacing gaskets and essentially rebuilding the boiler and tuning the burner to its maximum extent, and did a source test and believed it had passed the source test. As a matter of fact, The result came back just over 5 at about 5.18 of NOx. And that source test was submitted to the district for approval. Unfortunately, the district disagreed. And so CSI at that point was in a position where it argued with the district, and it submitted its position that 5.18 under scientific principles, rounding, et cetera, and various EPA and other scientific principles should be rounded down to 5. The district ultimately did not agree with that, and so CSI took some additional actions, including attempting another source test to see if it could hit 5. The numbers, however, were still hovering just above 5, so further efforts at source testing were aborted, and California Steel decided that the only way it was going to be able to achieve 5 was to replace the burner itself. A brief note, CSI did file a petition late in 2023. That petition was filed before the date that the prior variance ended. However, no date was available for a hearing before the end of the variance period. There are a couple reasons for that. One is that actually, according to the last minute order, the last day to submit an extension application had already passed by the time CSI had received the district's determination, the indeterminate finding as to the source test. And CSI did take a couple of weeks to try to work with the district to get that source test deemed passed. But once those efforts failed and the petition was filed, there was no date available before the end of the last variance. The reason I mentioned that, members of the board, is to be upfront about the fact that the way we noticed this hearing was as an extension to the last variance, because it was filed before the end of the last variance date, and in the alternative to seek regular variance relief. In fact, that's the way the public hearing notice went out. So we are prepared to move procedurally however the members of the board feel is appropriate. It may be more appropriate to have it as an extension, but we're open to discussion on that. The boiler is currently operating under the same conditions as the old variance. This was done with agreement of the district, and we can provide some further testimony about that. But essentially, a decision was made to continue operating the boiler with an understanding that there was an enforcement discretion by the district, which if CSI were not to prevail today on receiving a variance, obviously CSI could be subject to enforcement in that regard. So we believe the 6 variance findings have been satisfied. The petitioner is in violation of the rule at 5 ppm. This is due to circumstances beyond the reasonable control of the petitioner. The emissions here are extremely small. And in fact, you will receive a request to actually have the excess emission fee be calculated based on actual emissions rather than the minimum that the hearing board rule 303 requires. And during the period of the variance, the petitioner has agreed to conditions that are designed to reduce the amount of excess emissions and ensure that the company remains in compliance until it can receive its new burner commission and ultimately pass the source test. So thank you very much and appreciate your consideration today.
Thank you, Mr. Thayard. Ms. Chavez?
Hi, good morning. Yes. Petitioner's counsel mentioned that it was filed as a extension but we could also be heard as a regular variance. The district believes that either way would be supported by the health and safety code. If it is an extension of a variance, it would be longer than the year, and I believe the conditions provide increments of progress pursuant to health and safety code. But either way, the district would not be opposed, subject to the evidence presented today and subject to the conditions that are presented in the findings, proposed findings and decision. Thank you.
Thank you. Okay, Mr. Thayard, would you like to present your witness?
Yes. Okay, let me go back here. Okay, Mr. Parker, you were sworn in, but just to start us off on the right foot, can you please again state and spell your name for the record?
It's Harold Parker, Harold, Parker.
And what are you employed by California Steel?
Yes, I am. I've been employed by California Steel for 29 years, the last 28 as engineering manager.
And what is the job of an engineering manager?
So we handle all of the major capital projects in the plant, also any repairs and so on. So I've been through several large source installations, starting with reheat furnaces, another galv line we have built. So I'm reasonably familiar with the large sources there.
Are you generally familiar with CSI's operations, including the boilers that we're talking about today?
Yes, we have. So we're required to replace these two boilers. The old boilers were not going to meet the NOx rule unless we had added SCR to them, which we decided was not an economical thing to do with an old boiler. So we purchased two brand new boilers that were guaranteed at 5 ppm. We need to operate those two boilers for our continuous pickle line that provides the heat to heat the acid baths, which is cleaning the steel. That's then processed downstream into cold roll galvanized, which is the majority of our revenue. So we really do need steam. We have a third boiler, but it's a smaller 400 horsepower and it's on an emergency basis. So we have a limited annual hours we can use that boiler for. So not enough we can't fire it up and just run it. So in the past, what we did when we had this trouble with two, we rented boilers. So we rented boilers last year. We had those on site. So we were running one plus the rentals. But once we source tested two, the emissions are actually lower than the rental boilers. Those are in the neighborhood of 7 to 9. We're also running out of time on the rentals. I believe you're allowed a year to have rental boilers on site, and we're starting to run up against that time frame. So we met with council and talked to the district, and it seemed smarter to just keep running 2A with the lower emissions than the rental boilers.
All right, thank you for that summary. Let's take a step back. If you could just explain generally, I'll go to the next slide here. You were starting to talk about this. What is the manufacturing process? What do you mean when you say, galvanized? Just explain a little bit more of the manufacturing process and how the boilers fit in.
So on the screen, you see slabs, which we import and also bring in from domestic suppliers. We heat those up in our hot strip mill, where we have those two large reheat furnaces. After the hot rolling process, there's a black oxide left on the steel. Hot steel exposed to air oxidizes quickly. So we have to pickle it, we call it. So we run it through the 62-inch pickle line, which is hydrochloric acid. And the addition of steam heat to that makes that process more efficient. So everything that's going to get cold reduced and then galvanized is going to go through the pickle line, which needs that acid. So that affects cold roll, galvanized, and those products. And we have two galvanized lines that we try to keep fed because that's our main source of income.
So how many boilers, like large scale boilers, does California Steel operate?
We have the two brand new 800 horsepower boilers plus the third standby emergency boiler.
Got it. And just a brief reminder to allow me to finish the question before you start the answer. Thank you, Mr. Parker. So if you could just explain briefly then, how does the steam from the boilers fit into the manufacturing process? Why is it important?
We need the extra heat for the pickling process to be effective. So we run those pickled acid tanks up to a higher temperature with the steam. It's a once through, we don't recycle it. All that steam goes into the process.
So you mentioned you had two boilers. Did one of the boilers pass its source test?
Yes, it did. And they're twins. So number one did pass and number two so far has not.
Okay. All right, so do you remember being here in July 2023?
Yes, I do.
All right, so in that variance, we discussed, or hearing, we discussed certain actions that the company was going to take to try to achieve compliance with the 5 ppm standard. Can you, for the members of the board, explain, since the July 2023 variance, what work was done on the number 2 boiler to get it to achieve 5 ppm?
So we removed the burner from the boiler. We did notice some damaged refractory inside that area. We patched that up, reassembled the boiler, the burner with new gaskets, cleaned the tubes, inspected the boiler. We can't find any issue with the boiler itself. The tubes are clean. Replaced the fuel meter and then dried out the refractory and then tuned the boiler. And we've tuned the boiler numerous times. And it just doesn't seem to get below that 5.2 mark.
Mm-hmm. And in terms of were there conditions associated with that prior variance?
Yes.
And did CSI achieve those conditions?
Yes.
Okay. Did those conditions include providing monthly reports of progress to the district?
Yes, it did. And we carry on with that.
Got it. Okay. In terms of, so we'll move forward here. Okay, so once all those actions were taken, did California Steel then source test the number 2 boiler?
Yes, we did.
Okay, so explain, so when was that source test conducted?
We source tested in October. We had our source test contractor come out. We had retuned it to the best. And our difficulty is when we're tuning this boiler, we're using portable equipment that's not as accurate as the testing agency. So we felt we had some headroom. We're getting numbers in the 4s on the portable equipment. Once he hooked up and read it, he felt it was passing because we got a 518, which he felt was in the range of allowable error. So we submitted that. It came back, unfortunately, as indeterminate. So
when you say came back as indeterminate, just want to clarify, did the source test report indicate a passing
yes.
score? Okay, so when you say indeterminate, are you referring to, what are you referring
The
to?
district evaluation.
Got it. Okay. And do you recall when that evaluation was provided to CSI?
We got that in mid-November.
Okay.
So that was October to mid-November. We got that back. And then we scheduled another source test in December.
Okay. So we'll talk about the other source tests, but did California Steel communicate with the district about the source test?
Yes.
Okay. And in generally, what did CSI try to convey?
We felt that the error would have allowed that 5.18 to be read as 5. We understood there was a 10% allowance for inaccuracy in measuring equipment. That was not the case apparently, so we had to retest.
Got it. So you attempted another source test?
Yes, we did.
And what happened?
It was no better than the first. We were in the 5 to 6 ppm range again. So
Got it.
we canceled it as a source test, called it an engineering test.
Okay. And so at that point, having failed to convince the district that the 5.8 was passing and still hovering above 5 when you tried again, what decision did CSI make?
At that point, we decided that probably the most practical solution is going to be to buy a new burner. And it's not just a burner, it's a burner management control unit. It's the combustion air fan, the drive for the combustion air fan. All that is integral to the burner package.
And how much is that going to cost?
About $170,000 plus commissioning.
So does CSI continue to have a desire to achieve the 5 ppm
Yes.
standard? Okay. Okay, so let's talk about current operations. Is that boiler number 2 still operating?
Yes, it is.
Okay, and can you explain a little bit more about why the decision was made to continue to operate it?
Again, we checked with the district. Based on the initial source test, we are better than the rental boilers were. And we're running out of time on the rental boilers with that 1-year rule.
Got it. And do you have an understanding that if a variance or modification or extension of the existing variance is not granted today, that California Steel could be subject to enforcement to the end of the last variance?
Yes.
Okay. did CSI reach out to the district to communicate what it was intending to do?
Yes, we did.
Okay. Is California Steel continuing to follow the conditions of the last variance?
Yes, we're still submitting the monthly reports and having the technicians adjust the boiler or check the boiler monthly.
Got it. Thank you. Okay, so let's talk about alternatives. You mentioned a little bit about alternative, sources. So did California Steel investigate alternatives to operating the number 2 boiler?
Well, we're out of time on the rentals, so that's problematic. There is another heat recovery steam generator that's available part of the time, and we do use that when the schedules are coordinated. But that unit does not run as many hours as the pickle line runs. We have on one of the large reheat furnaces, we can make some steam, but the hot mill does not run as much as the pickle line runs, so it's not as available.
So what would be the impact of operating with only the number 1 boiler?
It would be disastrous. We would have to really slow down if we could operate at all, and we would lose a lot of revenue.
Okay, when you
And
say
a lot of contract violations.
contract violations, is that, yeah. So in general, what would be the expected economic loss if you were only using number 1?
That production would be about $750,000 a day.
Okay. You mentioned the 1 year. So can you explain a little bit? You said there's a 1-year limit on rental boilers.
That's our understanding. Once on site, you can have that boiler there for a year, and you can't just flip it with another boiler and get another year. You have a 1-year hard limit.
Got it. And then you mentioned something about emissions from the rental boilers. Did you, even if you could get a rental boiler, what kind of emissions were those rental boilers
We saw them in
getting?
a range from 7 to 9. It all depended on when they were originally permitted.
Okay. So those rental boilers, when you say 7 to 9, is that higher than 5.18?
Yes.
Okay. So would the rental boilers have higher NOx emissions than the number 2 boiler?
Yes, they would.
Okay. All right, so let's talk about this checklist and the plan going forward. Can you explain what is California Steel's plan going forward?
So we've ordered the new burner. We ordered that on the 5th of February. It does take 12 to 16 weeks. Right now, we have a promised ship date of the 24th of May. It will probably take 3 or 4 days, maybe 5 days to swap it. So we'll have to coordinate an outage or coordinate when the hot mill is running at the same time as the pickle line is to get in there and do this swap. And then we'll need some time to, again, recommission this thing, get the fan curve set up so we can get the NOx down to where it belongs.
When has the district required a permit application for the new
Yeah,
burner?
So
And again, wait for me to finish my question. Is a new permit application going to be submitted for the burner?
yes, it will be.
Okay. And what's your understanding of how long it will take roughly to get that permit
3 to 4
approved?
months for processing plus the 45-day EPA review.
Okay. So when is burner delivery expected roughly?
Late May, early June.
Got it. And what happens after the burner is delivered?
So provided we have the permit to construct, we will install that burner and then we'll start commissioning it.
Okay. And what does commissioning mean?
So there are fan curves that have to be set for the different firing ranges, and that has major effects on the NOx generation, controlling the amount of combustion air. That was one of the things we thought we corrected to get to the point where we were down in the very low 5s on boiler number 2. So the technicians will again set up the fan curves, run the boiler up and down, and try to get the NOx back down to where it belongs.
Got it. And after installation and commissioning is done, will the company be required to conduct a source test?
Yes, we would.
Okay. And that source test will be subject to the same review that occurred previously, correct?
Correct.
Okay. And what is the expected, or let me ask it this way. Why did the company change its request from October 31 to December 31?
That was based primarily on the fact that we had to go through the permitting process. So we were a little concerned that that may extend the time frame.
Got it. But if it's possible to do everything sooner, will the company do it sooner?
Absolutely.
All right, so let's talk a little bit about emissions. I may have gotten my number wrong there, but does Rule 303F provide a minimum excess emission fee?
Yes.
Okay. And again, can you remind me what the source test result was for boiler number 2?
5.18.
So
So
did,
0.18 in excess.
got it. Did the facility calculate what 5.8 ppm would be if measured over the, on a per day basis?
Yes, 0.171 pounds per day.
Okay, so factoring in the actual fee under Rule 303, can you explain what the difference is between the minimum fee and fee based on actual excess emission
It's
calculations?
about $71,000 higher for the minimum fee.
So is the company requesting that the members of the board today approve excess emission fee different from the minimum fee under Rule 303?
Yes, we are.
Thank you. So speaking of findings, has the company agreed to conditions proposed by the district?
Yes, we have.
And in general, what do those conditions require?
It's, I believe there's fuel source, fuel consumption on that boiler, plus the tuning report from the technicians.
Got it. Now, have you reviewed the conditions?
I personally have not.
Okay, but did you see, well, we talked about them,
Right.
correct?
Mhm.
Okay, did you see in the conditions that it included, 90 days, as you've testified, to install those kind of things?
Yes,
Okay, and those are enforceable deadlines under the conditions, correct?
yes.
Okay. Did the company consider curtailment in lieu of obtaining a variance?
Yes, we did, and we cannot find an economically feasible solution.
Got it. Once the new burner is installed, would the boilers, need to operate?
Yes.
Okay.
Yeah, in order to commission, the boiler needs to be in operation.
Okay, got it. Thank you very much, Mr. Parker, for your testimony. I will pass the witness.
Thank you, Mr. Thayard. Ms. Chavez, do you have questions for this witness?
Yes, just a few, thank you. Morning.
Good morning.
Earlier you talked about all the work that you've done to the boiler to try to get it to meet the limit. At what point did you find that you exhausted all your possible remedies and decide to do a replacement?
That December source test.
December source test?
Mhm.
Okay. And no other options were discussed besides replacing the burner?
At that point, it seemed the only practical thing we could look at. The boilers, for all intents and purposes, are identical. When you look at the boiler, the two bundles, the stack, everything, and they're right next to each other. So we couldn't see any other difference other than perhaps the burner itself.
And with replacement of the burner, is that a guarantee that it will be below the 5 ppm?
That burner is technically capable of below 5 operation. And it's been proven apparently in other sites too. So, and we're doing it on our number 1 boiler. So I don't know that I'm getting a guarantee with it because of the difficulty we've had, but it should be able to.
You mentioned earlier that these 2 boilers were purchased brand new and guaranteed to meet the emission limit. So this sounds like it's an abnormal situation. Have you heard about it in other facilities coming across this?
No, we haven't. We've done a little looking. I think there were a lot of people in the same boat with respect to delays as we were, but not within compliance.
Okay. And let's see, you said you are aware of the increments of progress provided in the proposed conditions?
Yes.
And will the facility be able to meet those increments of progress?
Yes.
And is it the facility's belief that you will be in compliance by the final compliance date December 31st, 2024.
Yes.
Okay. I don't have any other questions. Thank you.
All right, Ms. Chavez, board members? And I cannot see the board. If you can, Day, if you can, thank you. Okay, board
Madam
members,
Chair,
Mr.
I do,
Galapalan?
yeah, I do
Mr.
have some questions.
Galapalan, go ahead.
Mr. Parker, good morning. When you, I'm looking at Exhibit C where the district provided the report. Do you have that in front of you? I think it was renumbered to 14, but nevertheless, with the petition was listed as Exhibit C. That's the district response to the
Oh, to the source test evaluation?
report
Yes.
evaluation.
Yeah.
So they did indicate it was within the 10% margin of error,
Correct.
but the remediation was it was indeterminate, right? They didn't say you failed, but they didn't say you passed, but indeterminate, but it required a retest.
Right.
And so you said you read the retest, and you say hovering between 5 and 6. What was the number?
The retesting was getting down to 5.5, which would have been a failing.
Oh, it was 5. Okay.
Yeah.
All right. Not so even if it, but why didn't you you didn't submit that?
No, because at that point it was not going to be compliant.
Right. So it was around 5.5. So it would have rounded up to 6 then, which would have been considered a fail. Okay. All right. Okay. Now you're still operating under the permit to construct?
We are operating under the prior variance.
No, but your permit is, because previously it referenced relief from H 23.7 permit condition. So that's on the permit to construct, and you still need relief from that condition.
Yes.
Because that's the one that puts a 5 ppm limit.
Mhm.
Because I didn't see it in your proposed finding a decision, that specific condition. It referenced the rule, but you still need relief from that specific condition.
Sorry, from a legal perspective, I believe so, especially now that the district, I think, has required a new permit
Right.
for the burner.
Now, as you say, there's no guarantee with the new burner. And if suppose, I think the remediation is sort of, I think it's an enforcement policy. They don't issue a notice of violation when you're within the 10%, but they require a retest. And need to actually, I thought they required you to submit the retest, and then the determination will be made on a case-by-case basis. If you, of course, you're above the 10%, which appears you were from what you're testifying, that's a violation, you know. But if you're below, then it's a case-by-case, you know.
Yeah, and we did have a range of results, but none of them were below the previous number.
Okay, so because this could happen again, right?
There is a risk. It's a
Yeah,
cutting edge technology.
right.
So
So
we do understand that this burner is in use at several other large boilers in the state, and they're hitting 5.
Right. So right now, okay, so let me go back. The only report we have, or the determination is indeterminate. To make a finding, we need it's in violation. Have you got some communication, something to indicate that you are in violation of this condition or this rule? Or some indication that, you know, so that we can, because that's the first finding we have to make, that you're actually in violation. The documentation shows you're indeterminate. And the problem is because you didn't submit the retest, which you should have, in my opinion, you know, then the district could have acted on it.
It's a fair point. I'd have to look back and see. There may be some communication that we received in email communications about that issue in terms of, you know, from a legal perspective, I think viewing the indeterminate result and after attempting again, the last conditions to the variance require that a source test be conducted by the 1st of December. it was actually conducted before that and then reattempted on the 1st of December. On the 1st of December source test,
Okay, excuse me, Mr. Thayer, you're testifying.
you're right. I was trying to
So
explain a
I
legal
need the witness to provide the information. Does the witness have that information?
What we do have is an engineering test report.
Which shows indeterminate, that's, yeah.
Well, the December, we do have data from December,
Oh, from the retest.
from the retest that we turned into an engineering report.
Oh, you did submit something from the
We
retest?
did not submit it.
You did, but you have that report that shows you,
I don't have it with me, but we do.
but that shows you are not in compliance.
Correct.
Okay, all right. And,
We can provide that. We have somebody at the facility, and I may have it in my file that shows the numbers run of engineering.
for
And
me
they show
personally,
the
that will
fine.
be useful because then I can say, yes, you met the first finding, which is the easiest finding to make you in violation or not. And that shows you in violation, then we can move forward to the rest of the findings. So, at this point, there's no evidence that, indeterminate means indeterminate, and that again, okay, I'll save my spiel for later.
Mr. Thayer, can you have your office email that to our clerk?
Yes, I will do that. I may have to take a brief, do that at a recess
Okay,
and find that, but yes,
Okay.
I can find that information.
that's fine. All right, Mr. Bellicopponi, did you have more questions?
No, I think,
Well,
yes, no further questions. Thank you.
Okay, I have a question on reference to, and maybe I missed this, but you mentioned that there was a guarantee on this equipment. Is that correct, sir?
Was, and we are
Okay,
still
Did
battling.
that expire?
No, we're still battling with the original equipment manufacturer, and the contractor we purchased this from.
And where are you with that?
Not in a great position. That contractor is no longer in existence.
Hmm.
Been absorbed by another company. So we're doubtful we're going to see much remuneration from them.
How long have you been trying to negotiate with them?
For the past 6 months, I think that's my guess.
For the past, okay, you're guessing though. Okay, is there a way that you can get that information as well?
Yeah, our purchasing department has been working on that.
Okay. Do you have a copy of your original purchase agreement with the company, the original company?
I can get you that. Yes.
Okay, and do you have a letter or something to the effect where the company that took over is not going to honor that guarantee?
I know we've sent the demand letter. I don't know what we've gotten in return. Fortunately, the burner manufacturer themselves has been relatively cooperative. Their technicians are still coming out to help with the situation. There are 3 major players: the contractor, the boiler maker, and the burner maker.
Mhm.
Burner maker we're still working with. It doesn't seem like there's much the boiler maker can do. But our guarantee was through the original contractor. It was an purchase and install contract.
And how long was that guarantee supposed to be for?
Typically 12 months, but it has to achieve it to be able to start the clock running. So it has never achieved it.
I see, okay. Yeah, that information would be quite helpful. When we take a break, we can go ahead and ask for that information as well, if it's possible. We're at 10:26. Were there any other questions for this witness, board members?
Madam Chair, just as a follow-up, so the new burners and besides the burners, you're changing a couple of the controls and so forth on the burners. So it's a completely different vendor?
Nope, same vendor, Power Flame.
Same vendor, okay.
I understand there's really only 2 makers of these very low NOx boiler burners.
Okay.
Power Flame and I don't recall
it's-
the second one.
Identical as the
Yes, it is.
and everything?
Mhm.
Okay. All right, so everything you're replacing will be identical.
Yes.
Okay.
I don't believe any of it's been upgraded or gone obsolete in the time with the controls. So I
Right.
believe it's all identical.
Now, one other thing Mr. Thayer mentioned, and I think in his opening, that when he looked at the rounding principle, they looked at EPA's rounding principle. Can you reference a memo or something from EPA on regarding that? Do you have that or?
I have copies of letters that were said, those were more legal back and forth.
Yeah, okay.
If you'd like, I can provide copies of those materials.
Is that the 2009, August 27, 2009 memo? Do you know? If not, board members needed it, but I have it in my file, so
Yeah, so from a legal standpoint, again, because I don't, with respect, obviously I can't testify. I can say that we did provide some background in a couple of communications. I can't recall exactly which, but I'd be happy to show that we felt provided evidence that rounding principles should apply. But I can find that information. What we figured legally was that the hearing board would not want to hear or adjudicate whether rounding principles should apply, because that's not within the provision of the board. But we understand why that question is important for background.
okay. Thank you.
Any other questions, board members? Okay, I don't see that anybody has their hand raised.
No hands raised, Madam Chair, that are on Zoom. And it appears that there are no members of the public in person that want to make any testimony or comments.
Okay, all right. Why don't we go ahead then and take a 15-minute break, and that'll allow the council for California Steel to get the information that we're requesting. So we're off the clock for
Well,
15.
briefly, so I make sure that we make good use of our time. Sorry, Madam Chair. I want to make sure that I'm clear on what we need to provide. I did forward to Madam Clerk, I found it as we were talking, the engineering runs for December 1, 2023 source test, which shows, depending on the run, that there was coming up between 4 to about 6-ish on various runs. So hopefully we've satisfied that. But I want to make sure that we are providing the other information. I think I heard
Purchase order. with
purchase
the
order,
and the demand. I think I have.
demand letter to the manufacturer.
Uh-huh.
And is there anything else that members of the board would like to have us provide?
Mr. Balagopalan, did you have another document you requested?
I think I'm satisfied with that test report. That way I can use that in my deliberation.
Mr. Ali?
Yes, Madam Chair, I think we ought to afford the gentleman at least 30 minutes, if not 20 minutes perhaps, to be able to gather, because it seems to be a tremendous amount of documentation and potential coordination between his office and the clerk's office and what have you. So I'm not for sure if everyone else feels that way, but.
Well, let's ask Mr. Thayard. Mr. Thayard, how long do you think it'll really take you?
I think if we recess till 11, we'll have everything you need.
Okay. So that is exactly half an hour. All right, let's return then at 11 a.m.
Chair?
Yes,
Chairman, you could take one of the consent items, after
we
15.
could do that. Why don't we go ahead and do that then? So for California Steel, we will come back at 11. And in the interim, thank you very much, Mr. Pearman. That's a very good suggestion. Let's go ahead and start with AES.
Okay, are we taking a break first and then
Yeah, let's.
I think Mr. Pearman said after 15 minutes, we do that.
Yes,
So,
yes, we're gonna take a 15-minute break. So we're off the clock for 15 minutes, then we'll come back and we'll do AES on consent. So stop the recording. Okay, who are we missing? Dr. Abraham?
I can start the recording, Madam Chair.
Yes, I'll
Okay.
wait a few more minutes for Dr.
Okay.
Abraham.
I'll wait for your cue.
Thank you. Okay, we are back on the record. I'm sorry, I did not hear that.
Our clerk is not back, though.
Oh, okay. See, that's why it helps to be able to see that desk.
Can you knock on the door, Makai?
Sure.
Thanks. The secret knock.
Yeah. And a nice little secret out there. Yeah, right. Okay, take your time. She says,
They already started it, I believe.
All right, we're ready.
Good to go, El Teresa?
Yes.
Okay. All right, our next item is AES Alamitos LLC, case number 5278-3. This was in reference to a short variance, rules number 203, 2004, and 3002 regarding this matter being placed on consent. We have some exhibits to mark. And the stipulation to put this matter on consent will be exhibit number 2. The declaration from Jose Perez will be number 3. Excuse me. And the findings and decisions of the hearing, the proposed findings and decision for an order granting a short variance and the proposed order, that will be number 4. And with that, we can go ahead and start any deliberation. I thought we had did we not have a hearing board email?
Yes, Madam Chair, I think I did send
hearing?
an email
Yes. So
regarding,
that would be marked as HB1.
yeah, for ES to change the date from there were 2 comments. Basically, one was the date and some reference to when the interim was held, I believe.
Okay. Are you in agreement with that, Madam Clerk?
I don't have a copy of that, but I know that the clerk's the front desk does, so I will get that right now.
Okay,
I have all the other documents other than
okay.
the-
Let's go ahead then and proceed. We don't hold up California Steel either. And based on your emails, did you want to go ahead and start the deliberation, Mr. Balagopalan?
Yes, I think the 2 comments I had was one, just more of a reference to when the previous hearing was held, because it referenced it in the finding a decision document. And Mr. Ali, I think this was put in my inbox. Maybe it's meant for you. It says Ali up here, so
Okay.
maybe that's why you didn't. get it, you know.
Thank you. No problem. Thank you, sir.
So, and then the other one was the date the end date extended beyond the 90 days. So it would have been 91 days in the order. So they came back and changed it to, I believe, April 28th, which wouldn't make it, less than 90 days, 89 days. So that,
Okay,
that was okay. So
mhm.
I had those were the only two issues, just changing the final compliance date to instead of April 30th to, I think they came back with April 28th.
Was this the one that also had, they left off Mr. Pearman's name? Is this the one?
That's the other one, I think.
Yes, yeah,
Okay,
yeah.
okay, all right. So, did you want to go ahead then and start, Mr. Balagopalan?
Yes, I think as we granted an interim variance previously, and on January 30th, 2024, and this request is for a short variance for the same event, basically. And they need a relief from permit condition D 12.1, so they can do the basically do the the testing, and so that the hang on one second, I'm trying to so that they can the pressure differential is exceeding, so they need to make some correction and so forth. So I based on, since we didn't find any issues during the interim variance, and the condition that they're proposing is identical almost, except for the end date for the short variance, I don't see any reason why we cannot grant the variance for the request for the short variance.
Okay, any other comments, board members?
Just as we found before, the issue is, I wouldn't call it a technical one, but it's this pressure differential. It's not really exceeding any emission standards per se, just that particular condition. And they're going to take appropriate steps to both monitor that and fix that. So I think the short regular variance would be appropriate.
Yes, I too agree for those same reasons. I think we're just going down the same path and trying to bring them into compliance. It's not always easy with these larger facilities, and when they're at Title V, and then when there's also the alternate operating conditions that are part of the consideration. So, but I also agree with my fellow board members that I can also make the findings for this variance.
I just wanted to correct myself. I said it was for testing, but it was, as Mr. Payman pointed out, it was the pressure differential exceeding the allowed range. So they're trying to correct that. So it's not any emission testing per se. So there shouldn't be any excess emission during this period.
And I think they also mentioned the maintenance and the cleaning of the selective catalytic reduction device, the catalyst for it. So that's also a huge part of part of their reasons for requesting the additional time as well. Okay, any other discussion?
I'd like to lay a motion upon the floor.
Okay, do we have a second?
Second.
All right.
Well, we need to allow me to entertain the motion with a little more specificity in the matter of AES Alamitos LLC facility ID number 115394, case number 5278-3. I move that we grant a short variance commencing February. Hold on one second. Let me just click over. February 21st, 2024 through April 28th, 2024, which is the final compliance date. From the following rules and subsections, the applicable rules for which we're using to grant a short variance: 203B, 2004F1, and 3002C1, permit condition D11211, and administrative conditions section E2 and E5 of the facilities title B permit for the 2 selective catalyst reduction parenthetical reference SCR units identified as C170 and C178.
Okay. And if I may entertain a friendly amendment, the location, I don't think you mentioned it, sir.
Yes.
Did you mention it? 690 Studebaker?
As a matter of fact, I did not, but I'll go ahead and I'll simply loop that in.
Okay.
The address in question is 690 North Studebaker Road, Long Beach, California, 90803. And just for the record, the facilities ID would also encapsulate the address. So I respect the amendment, but the facility ID would reference and include address as well as the facility.
Mhm.
Is there a second?
We do mention that normally.
Just a friend, I don't know if you mentioned the conditions as the proposed in the finding and decision, the revised finding and decision document.
Yes, the documentation that's online would include conclusions as well as orders.
I believe there was a revised, I forget what we identified, I didn't mark it, what exhibit. So anyway, there was a revised, they submitted a revised finding and decision document, number 4, sorry. So the condition will be as in exhibit 4 in the proposed finding and decision document revised.
Yes, I'll accept that amendment.
Okay.
I'll second that.
All right. Any other discussion on the motion? Seeing none. Mr. Balagoplon, how do you vote?
Aye.
Mr. Pearman, how do you vote?
Aye.
Dr. Abraham, how do you vote?
Aye.
Mr. Ali, how do you vote?
Aye.
And I also vote aye, so that's passed unanimously. Okay, and let's see, do we have time to? Are the,
Yeah, back in.
are they back in? Is council?
No, they're
No,
actually.
okay, so let's quickly go to Torrance.
We're ready at the discretion.
Okay, well, Madam Chair, the gentleman states he's ready, the petitioner as well as the respondent.
Okay,
Both
Right.
are signifying that they're ready.
I can't see the whole room, so thank you for that, Mr. Ali.
No problem.
Okay, so let's go ahead and continue. We were at the point of gathering more information from the petitioner and to give us more information to be able to come to a prudent conclusion on this. Mr. Thayer, do you have that information now?
Yes, members of the board, thank you for your very astute questions. Fortunately, in the 30-minute recess, we were able to find the documents that the members of the board had requested. So I want to proceed as per appropriate procedure and protocol, since this is the period of time when it's the board members' turns to ask questions. But I can explain what I provided, and then if you'd like me to ask a few questions about it, or happy to defer to you. But
okay, so in trying to be careful of not having you testify, is your witness able to present that information?
I think so. So we have emailed you the copy of the original purchase order, which is a system printout.
Okay,
Can you hear me?
yes, I can. But I'm trying to see the document. Is that the one
Yes,
that's dated?
Yeah, so briefly, I'll explain what I sent, and then, of course, the witness will need to testify about what exactly is in it.
That's
But
fine.
I'm up on the screen.
yes, I can even pop up on the screen
So we all are talking about the same
what I
document.
provided. So the first document that I provided to Madam Clerk is a I think it is going to appear now on the screen. This document is an Excel spreadsheet of the engineering runs from the
December 1st.
December 1st source test. The corrected values are along the right, which show numbers in the low fives to the high fives.
If you scroll up to the top, you'll see the headings. So this is the data from AKI, our source test company, from that day in December when we ran the test the second time.
Okay,
Just for the record, this will be exhibit 16 then?
I
Yeah.
believe so in order now.
Yes.
Yes.
Okay.
yes. Okay,
Verify when you said low fives to high fives, which column was that?
Far right. So there's a lot of high fives here too.
the Knox.
Yep. Knox at
Thanks.
3% is the right column to be in.
Okay.
So F, column F. Yeah, and there's even some sixes in there.
Mm-hmm.
Yes.
Thanks.
There,
Okay. Are there any questions, board members, on that document? And maybe I should even defer to Ms. Chavez. Do you have any questions on this document?
No questions, thank you.
Okay, board members? Since I can't see you.
Dr. Abrams,
No questions on this one? Okay.
Madam
Then-
Chair, Dr.
Yes,
Abrams, yes. Can I
go
speak?
ahead.
Great, thanks. I was just curious, so you're saying that last column, so did something happen at that 10 a.m.-ish where there were like 27, 14s, 9s?
That is, this particular burner has been somewhat unstable. I can't explain why it would jump if we scroll down there a little bit more.
Mhm.
Sometimes it's the O2 going a little high, which will throw off the sensitivity perhaps, but we're keep going down at 10 a.m.
I don't see a timestamp.
It's on the left. You're at 9:40 right now. Keep going.
Okay.
So 10 a.m. we're at 6:09, 6:02. Keep going down.
Mhm.
So are these the numbers or does it get worse? There we go. Yeah.
Oh, wow.
What's the gap there?
So the gap would have typically been, it's only 4 minutes. That's not probably long enough to do any tuning. So at this point, as we've turned it into an engineering one, we're trying to make adjustments to get it right. And they could have theoretically made a bad adjustment at that point, and then saw that it was bad, because I think within about 8 minutes there, it gets back to where it had been. I'd have to try to go back to AKI and the technician from the boiler company to find out. But during an engineering run, we'll often make changes. You know, he'll stop testing. We'll try to make an adjustment to try to figure out what's going on and what we're doing to improve it or hurt it. But obviously something hurt it there, and then they got back on track.
Thank you for that.
Okay, any other questions on this document?
And Mr. Balagopalan, did you have questions?
No, I don't. I mean, I do have, I just want comfort. I will ask district, inspector to, Madam Chair, to just, if they agree, with later, if they, while I know this normally sent to another group to verify, but they do agree that this would the numbers that do indicate non-compliance with the standard, that's all, confirmation.
Okay, you want to ask the district engineer, correct?
Yeah, and, or the inspector, if
Okay, Ms.
there's no,
Ms. Chavez, do you have that
you know,
member of the staff there?
I have, yes, I have an inspector here.
Okay. And if you can identify him for us and
Oh,
identify whether he took the oath?
Did you want to finish going through the rest of the documents before moving on to my witnesses?
Let's go ahead and do that. I did want to make sure that he's aware that it's specific to this document so far. So yes, let's go ahead and do what would be exhibit number 17. What's your next document, Mr. Thayard?
Let's see, working in real time here. We also have, in no particular order, we have the demand letter that was sent by a different law firm to the manufacturer of the burner.
No, this is not to the, this is to the contractor who our contract was with. Heat Transfer Solutions is our subcontractor. They purchased the burner, they purchased the boiler. So,
Okay, understood.
and I believe MCOR Mesa Energy Systems is the company that they've been rolled into. That second name there, Mesa Energy Systems.
For the record, the board will note that the date is today. I am trying to get confirmation. I was told that it was sent yesterday. This is not a signed version of the letter, but as you can see, it's quite detailed. We could put it in as evidence with the caveat that I do not have a signed version of this letter at this time.
When was it requested?
We've been going back and forth with Heat Transfer for months. And I believe we got to the level of the demand letter in January, but it hadn't been transmitted to them. We've been working with a different law firm, putting all our ducks in a row to get this demand letter out. So I think it looks like it's going out today. I thought it was yesterday.
Okay, and Mr. Thayard, is your firm involved with this aspect of it?
No, we are not directly involved. We did ask them, have you submitted a warranty claim essentially against your first burner manufacturer? But we did not. Moore and Van Allen is a different law firm. We have no direct involvement with it.
Okay. All right, so let me ask your witness then. Is this the only law firm at this point that has been involved with a demand letter?
Yes. For corporate and business type law, we typically use Moore and Van Allen.
Okay.
Shepherd Mullen for environmental.
So when did you contact them to represent you against the manufacturer?
I believe those conversations started about 6 months ago. Let me see if I have that. To basically get them into the loop. To a point, Heat Transfer was cooperating. But as it seemed like they were not going to be successful, then things took a turn. And then it seems like they've been rolled up into a different company now.
So did they go bankrupt or were they just acquired?
I believe they were acquired by this other company.
Okay. All right. All right. Any other questions, either Ms. Chavez or board members? Ms. Chavez first.
Questions, thank you.
Board members?
No questions.
Okay. All right, let's go to number 18. Mr. Thayard?
I did find my email just a moment. We've been talking to Moore and Van Allen since last June on this matter.
Okay, good to know. Thank you.
So the next document is not one you specifically asked for, but it appeared relevant. This is Well, let the witness testifies to
This
what
is
this
the
is.
current purchase order directly, well, not directly, again, we're buying this through Boiler Equipment Company, BEC. They're a sub-supplier, they're a reseller of Power Flame equipment. So we're buying the burner from these guys. And this is that purchase order.
Is the burner brand new or is it used?
This is brand new. But the same model number.
Okay. All right. Any questions on this, Ms. Chavez?
No, thank you.
Board members?
Just for clarification, and maybe this is for Mr. Thayer, did you want to make this an exhibit? And because sometimes I know companies don't want to show the dollar amount. So, but do you have any
Yeah.
issues with?
Thank you for the question. No, we can make it an exhibit. The witness testified as to the approximate cost. He said about $250,000. This validates his testimony. So we're okay putting it into evidence.
And that's number 18. To reiterate. Okay. Any other questions on this purchase order? Okay. Do you have another document, Mr. Thayard?
Yes, Madam Chair. We also wanted to provide you with this letter, which I'll let the witness explain what this is.
What you see here is the original proposal from Heat Transfer from September 2021 to provide the complete turnkey system with 2 boilers, a deaerator, and an economizer for the equipment. So within this, it's right at the bottom of the screen is the Power Flame burner, the bottle UCM 800 with the less than 5 ppm NOx. So this is what we ordered, and we do have attached our electronic purchase order, I believe.
Okay, and I see in the paragraph above, under your scope of work, that it's a 25-year manufacturer's warranty on the boiler.
Yes. So what you see on the screen now is the purchase order to Heat Transfer Solutions to buy and it was a turnkey. They were also doing the installation. They did the demolition of the old boilers and the installation of the new ones. And then on the back of that paper copy is the T's and C's that Olivier will forward here in a second, as soon as it gets in his email.
So to clarify, Mr. Parker, this is the purchase order for the original boiler, the entire system.
The complete installed boiler system.
That would include the burner.
Yes.
And this document, the last exhibit 19 that referenced the 5 ppm NOx, does this purchase order match up with this letter?
Yes, it does.
Okay,
This is the purchase order for that proposal.
got it. So in other words, when you were issuing this purchase order, you were referencing a letter which said that you were going to get a less than 5 ppm NOx burner.
Correct.
Okay, thank you. We can mark this as exhibit 20, I believe.
Yes. Okay.
And I am in real time, which I have not forwarded yet. I'm waiting for Mr. Parker's terms and conditions document to come through.
Very difficult to read because it's fine print.
And I have not seen that come through yet.
But that would be 21.
Well, just to clarify, this is the terms and conditions for the letter from September 17th?
It's our standard terms and condition. It attaches to every purchase order. And that should include the 12-month warranty.
Okay, so
For
the terms
boiler.
on page 10 of Heat Transfer Solutions, that letter is different from the one you're looking for?
Right, that's an
Got it.
addition.
Thanks.
So if the seller could potentially offer better warranty than we asked for.
Thank you.
And we're just waiting for that.
Okay, I'm going to forward this. Again, this is real time. It's like playing jazz. I am forwarding this document to the clerk and to Ms. Chavez simultaneously. And I am going to pull it up onto the screen. Mr. Parker, can the document that is now up on the screen, can you direct us to where the warranty is regarding the burner, in which paragraph?
Trying to find it. Where's the date?
I'm looking for it here myself.
Paragraph 8 talks about workmanship, but it doesn't, I'm not seeing a duration in there.
I apologize.
But I believe paragraph 8 is probably, because it even gives us the right to return the goods.
Yeah, I see paragraph 8 does provide language with regard to the warranty and right to return. I don't see a 12-month, I don't see a date here when it ends, so.
When did you start having trouble with that burner?
From the very beginning of commissioning of that boiler. So
Okay,
that
and
takes us back to the first variance. So recall, we actually had a large problem with the delay in delivery. So we finally got that boiler installed, and I think that timeline was in the last variance. I don't have it in front of me.
so
But
from the time that you received it, installed it, when did you notify the manufacturer that it was faulty?
immediately, we brought the manufacturer's technicians out to try to continue to tune the boiler. They were convinced they could make it work.
And how long did they work on it until they gave up?
About a year. Well, from second quarter last year to the end of this year, the end of 23.
And did they write any conclusion?
They did not. At that point, heat transfer ceased to exist, it seems like, and we've been dealing with the successor company and dealing directly with PowerFlame.
Okay. I don't have any further questions. Ms. Chavez, do you have any questions on this document?
No question, thank you.
Board members, any other questions? Since I can't see you.
So this document will be exhibit
21. Okay.
Okay,
Did you
Madam
have
Chair.
any other
are we done
documents,
with
Mr.?
Are we
I'm
done with
sorry, Mr.
exhibits?
Ali.
Yeah, just curious, are we done with exhibits?
That's what I was just gonna ask. Mr. Thayer, is that the last one?
That is the last document I have, unless the members require or request us to provide anything else.
I don't have any other requests. Board members, any other requests?
No.
Okay. All right. Seeing none, and we have no further questions on these documents, and they have been submitted for evidence.
Send you the signed
We
copy.
can go ahead and move to the closing documents. However, before we do, are there any members of the public, Madam Clerk, that you see who either want to testify or provide a comment?
Currently, Madam Chair, there are no members on Zoom with their hands raised. And there appears to be no members in person to make comments or public testimony.
Thank you. Okay. All right, Mr. Thayard, you can go ahead.
Madam Chair, I did
Yes.
have a question for the compliance folk, just to,
Oh, that's right. That's
information.
right. You did. Go ahead. And if Ms. Chavez, if you can provide that member of the staff.
Chair, I don't believe he took the oath this morning.
Okay, you don't have your microphone on.
I don't believe he took the oath this morning.
Okay, sir, if you can please stand. And if you can give your name and your title.
My name is Paolo Longoni. My title is Air Quality Inspector 3.
Okay, and stand up, remain standing, hold your right hand up. Do you swear under penalty of perjury that you will be telling the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
You're
Okay, if you can spell your name for the clerk and your title.
Name Paolo is spelled Paolo. My last name Longoni, Lon like in Nancy, Gon like in Nancy, I.
Okay. All right.
Thank you, Inspector Langoni. Just a few questions. What's your familiarity with California Steel?
They have been one of my reclaim facility for the last 5 years.
Okay. And are you familiar with this issue of boiler 2 being not demonstrating its compliance limit?
I am.
Okay. And has actually compliance and enforcement previously issued an NOV to CSI for not meeting its emission limits on boiler 2?
Yeah, I personally did. After receiving the source test results from March 15, 2023, I issued violation number P79202 on May 31st, 2023.
Okay, thank you. And then there was a new source test done in October. And was there any NOV issued for that one?
No, I didn't issue an NOV because according to our internal policy, if a result is within a 10% margin, we require the company to retest the unit. And that's also consistent with the source test determination done by the source test department, which concluded that the source test was for NOx indeterminate and require a resource test.
Okay, thank you. And so today, petitioners submitted these runs from the retest that they began. And have you seen these before today?
No, I have not.
Okay, but you reviewed them today?
Correct.
Quickly. And did the retest appear to meet the emission limit of 5 ppm or continue to be above?
It seems most of the numbers are above, once corrected to 3%, are above the 5 ppm limit.
Okay, but this has never been submitted to source testing for review.
Correct, because the source test was not completed, it was aborted in the middle.
Okay. But is it compliance and enforcement's opinion that CSI has never or has not demonstrated compliance with the 5 ppm emission limit for
Correct.
boiler 2?
Correct.
Okay. That's all my questions. Thank you.
Okay. Mr. Thayard, can you, do you have questions for this witness?
I do not.
Okay, board members?
Yes, Madam. Mr. Longoria.
Palan?
Yes, thank you. So you mentioned the policy is to, when source has come back with the finding that's indeterminate, there's a requirement to retest, correct?
Correct.
And then the facility should submit the results of the retest to the district for further review, correct?
Correct.
And they did not do it in this case.
They did with the second test after failing the first one, but they never submitted this one from December.
Right. When you say they did, I mean, they did the test, but they didn't send the report to the agency for review, correct?
You're referring to the initial source test?
No, the retest.
The one in December.
In December.
The third one.
Right.
No, because the test was never completed.
Just, and as you indicated, this is the first time you're seeing this report.
preliminary report. And based on your observation, and let's make sure we're all looking at the same column, and that is the last column, knocks at 3% O2. And based on just a, preliminary look and based on your observation, it does appear, would you agree that they are above, even with the correction to significant figures, 10%, they are above that? And I think you testified to that, right?
Correct.
Okay, so, and you would say, and I know normally it has to go to a different division to get a final report, but based on what you see before you, would you say that they are in violation of the condition to meet the 5 ppm?
Correct.
Okay. Okay. What happens I know they didn't submit it, but let's say if the source says, and this is just for my, if they had come back and it was within the 10%, what do you know it's done on a case, how it's handled? Do you know how the enforcement handles that?
They submitted this one. This will be the third source test, the second within a 10%. Most likely we would issue a violation.
You would?
Yes.
Okay. All right. Thank you.
You're welcome.
Any other questions, board members?
None for this witness for me, but do you have someone from permitting here? You have
I
someone?
do.
Okay, I'd like to hear that too.
Okay.
Okay, I did not hear that exchange at all.
Sorry, I do have somebody from permitting here.
Okay. And is it Mr. Pearman who wanted to speak to somebody from permitting?
Yes, but I don't know if anyone has questions for the current witness still.
Dr. Abraham?
No, no current questions.
All right.
Member Bagalopolan's question did spark one question from me, if I'm allowed to ask.
Yes, sir.
Mr. Longoni, thank you very much. So you weren't provided with the engineering runs that you saw today, but did CSI inform the district generally that it was above 5 when it tried again?
Yeah, they did.
Okay, thank you very much.
Any other questions for this witness? Okay. All right, Ms. Chavez, do you want to present the member from permitting? Thank you very much, sir, by the way.
Madam Chair, I don't believe Ms. Rios took the oath either.
Okay. Please state your name for the clerk and spell it, please.
Yes, my name is Sarai Rios, spelled first name Sarai, last name Rios, Rios.
And your title?
Air quality engineer in the engineer and permitting department.
And you've been there for how long?
Going on 5 years.
Okay. And please raise your right hand. Do you swear under penalty of perjury that you will be telling the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay. Ms. Chavez, did you want to ask questions of your witness?
Sure, just a few. Thank you. Ms. Rios, can you talk about your familiarity with CSI?
Yes, I have been involved with the permitting of this project since the initiation.
Okay. And so you've been aware of the problems with the boilers and meeting their emission limits?
Yes.
Okay. And have you had continuous discussions with CSI over their compliance plans and their plans to move forward?
Yes.
Okay. And is engineering and permitting in agreement with their plans to replace their burner to come back into compliance, or sorry, to come initially into compliance?
Yes, it's correct.
Okay, thank you. I don't have any questions.
Mr. Thayer, do you have any questions for this witness?
Yes, just a couple. Thank you very much, Ms. Rios. During the process of working on this boiler and the burner, has the company maintained communications with the district?
Yes, there's been constant communication.
Okay,
Mhm.
thank you. And thank you. No further questions.
Okay, board members, questions for this witness? Mr. Pearman?
Oh, sure. First, they have not yet submitted an application for the new burner permit to construct.
That is correct.
If a permit to construct is issued, what's the process once the facility says we've completed construction pursuant to the permit? Does AQMD then have to come out and kind of verify and confirm they've constructed it properly according to the permit?
In the permit, typically we have conditions for source testing. So that would be the next step. They would notify us, okay, we've constructed the equipment, typically through email. And then they would have to go ahead and source test to confirm that they're in compliance with the limit.
So
Yeah.
the source test compliance would be measured and verified before the permit to operate is issued?
That is correct.
But you feel comfortable based upon your knowledge of the work they plan to do that within 90 days of issuance of the permit to construct, they can complete installation, complete the source testing, and get the permit to operate from the district?
Yes, I do believe so.
Okay, thank you.
Any other questions from the board? Mr. Balagopan?
Good morning, Ms. Rios. Are they still, currently they're in violation of, there's H 23.7, is that correct?
The 5 ppm
5
limit?
ppm,
Yes, that's
a
correct.
condition.
Yeah.
Okay. Now, are they, they're Title 5 facility because it's going to EPA for the review, correct?
Correct.
Is there any, I didn't see in the permit tagging for any NESHAP. Are they subject to any federal regulation?
They are, I believe it's tagged generally. I forget the section. I think it's section K, but they are subject to those EPA requirements, I believe.
Any specific NESHAP?
I don't know off the top of my head, but I know it's for commercial industrial boilers.
Okay.
Yeah.
So, okay, I didn't see it in this or the previous, but
Okay.
it's not a complete permit, so, you know, that's, it's possible.
Yeah.
So the other thing is, they are going to submit a Title V, and it's, do you know it'll be treated as a significant, de minimis, how, and the reason I'm asking is how long will, you know, EPA's review will take? They have maximum 45 days.
Mhm.
So do you know first how it will be classified, the revision?
Yes. So initially it was classified as a significant since it's going to be a completely new equipment and based on like the emissions. So I believe it would still be considered the same, a significant revision. Yeah.
Okay. And then do you, I know would you request EPA to expedite the review so it can shorten the 45 days or?
Yes. Yes, we are going to be requesting for EPA to do the expedited review.
Oh, all right. I have no further question. Thank you.
Okay. Thank you.
Thank you.
One more question. So, condition 3 said they would conduct source tests, within 45 days after unit operation. But I take it operation then means you can operate for purposes of ensuring you've satisfied the permit to construct, since you said that the permit to operate would not issue until after they had passed the source test.
I apologize. What was the question again?
Well, condition 3
Yes.
says among other things that they'll conduct source tests to determine compliance with permit conditions within 45 days after unit operation. But
Yes.
you just told me you have to do source tests before you get the permit to operate. So that term after unit operation must mean somehow you're able to operate under the permit to construct to confirm compliance with the permit to construct conditions, it seems to me.
Yes.
Otherwise, it doesn't make any sense.
With the issuance of a permit to construct with equipment, they will have to operate the equipment in order to source test it. So that is under the definition of a permit to construct, although it's not explicit here. So I apologize for it not being clear.
No,
Yeah.
I appreciate the clarification. Thank you.
Any other questions from the board members? Okay, seeing none, and you don't have any redirect questions, Ms. Chavez or Mr. Thayard?
Madam Chair, just, I think based on Mr. Payman's question, and condition number 3, I don't know, Ms. Rios, if you think maybe that unit operation refers to after the modification is completed, correct?
Yes,
Because
that's
they'll be
correct.
continuing to operate, but
Yeah.
it really referring to the new burner operation.
Yeah, the new burner
Burner
replaced,
operation. So
yeah,
that's,
to operate the new. burner.
Right, the complete installation of the new burners, that's, okay.
Yes,
All right.
correct.
Okay, anything else? Either Ms. Chavez or Mr. Thayard or board members?
No questions for me.
Okay. And none from the public, is that correct, Madam Clerk?
That is correct. There has been no changes to the members on Zoom and no changes to those in person regarding comments or public testimony.
Yeah, I misspoke. I meant comments and or testimony, not questions. All right, with that, thank you, Ms. Rios.
Thank you.
Okay, and now we can go to closing statements. Mr. Thayard?
Yes, thank you, Madam Chair, members of the board. Very much appreciate your time and attention to this matter today, including the probative questions and requests for additional information, which I'm happy we were able to provide. When you're starting a preparation for a petition hearing, you want to streamline things as much as possible while providing information that you think is relevant. And the background information that the esteemed members of the board were asking for, fortunately, we did have it at our fingertips and we're able to provide it, and hopefully that provides and bolsters Mr. Parker's testimony and the request today. So in closing, I believe that this company, California Steel, has demonstrated the 6 findings necessary to obtain a variance from this board today. Just a couple of points. Number one, this company has been working very hard on this burner and the boilers for a long time. They have commissioned, they have tuned, they have brought in the manufacturer. They have done everything possible to achieve 5 ppm with boiler number 2 using the existing burner. These actions that they took have always been communicated with the district. As you heard Ms. Rios agree, this company has been very transparent about its plans, about what it wants to do. When it decided that a new burner was the only way that they could go after exhausting every other option to achieve 5 ppm with existing equipment, they moved in that direction. They do have claims that they are pursuing against the manufacturer for failing them, despite more than a year plus of tinkering that has tried to be done to achieve the standard. CSI has spent a lot of money. You heard the testimony today, just with regard to the new burner. It's going to cost another $260,000 or so, not to mention the resource drain and all the money that has been spent just getting to this point to tinker with the existing boiler. The excess emissions here are relatively small, and the conditions that have been agreed to with the district in negotiation are solid, robust conditions that are designed to reduce those excess emissions to the maximum feasible extent. This includes regular tuning. It includes constant monthly reports to the district. It includes communication when install occurs, when commissioning occurs, and certainly when source testing occurs. The district has made it clear that they did require a permit to construct for the new burner, and the company has readily agreed and will be providing that permit application on or before February 29th. So California Steel has taken all actions within its reasonable control to achieve compliance with the 5 ppm. And now, because this new plan of action requires the installation of a new burner, it requires lead time on ordering. It's already been ordered. It requires a permit to be issued by the district, including the 45-day review. It involves installation of that burner. And so based on that, we respectfully request until December 31. Now, you heard me say that I was also going to be requesting a ruling from the board that the excess emission fee should be paid based on actual emissions and not with regard to the minimum fee. We defer to the board's good judgment and discretion on that. We believe that that would still be a significant cost savings, even if we measure it at some level above the 5.8 where it was actually source tested. You saw the exhibit. The numbers generally, except for a few hiccups with some bad tuning, were generally in the 5 to 6 range. And with that, I want to thank district staff. I want to thank Ms. Chavez, with whom I've been in very close communication with over conditions and over the legal aspects of this variance. And I want to thank permitting and engineering staff from the district today for working with the company. Thank you very much for your time. We believe the 6 variance findings can be made, and we respectfully request a variance up to December 31, 2024, with certain conditions that effectively act as increments of progress in terms of installation, commissioning, source testing, et cetera. Thank you very much.
Okay, thank you, sir. Ms. Chavez.
Yes, thank you. As you have heard, the district does agree that California Steel has exercised diligence in attempting to achieve compliance and has remained in constant communication with both engineering and our compliance departments. And the district is agreeable with their plan to move forward and achieve compliance. The district is not opposed to this variance, subject to the conditions provided by the district, and those are, like I said, presented in the proposed findings and decision. The district does not generally take a position on excess emission fees, but the district does not object to the request by petitioner. Thank you.
Okay, thank you very much. All right.
Make 2 comments.
Yes, Mr. Pearman.
So again, the parties presented us an option of treating this as a regular variance or an extension with increments of progress. And I know you both mentioned increments of progress. So is your preference that we treat it as an extension, or what's your preference there?
Ms. Chavez and I conferred about this, and I won't put words in her mouth. My sense is that it makes more sense to treat it as an extension of the existing variance. It has the same case number. It was filed before the expiration date of the old variance, and it's simply a matter of the calendar and the end of the year not allowing for hearing dates to occur that we're here today in February. So I think we can treat it as an extension, and given that the conditions are written specifically to essentially act as increments of progress, the 90 days, 45 days, et cetera, that we'd rather treat it that way, but we defer to the members of the board.
Ms. Chavez?
With that.
So,
right.
so Mr. Pearman and Mr. Balakapalan, so Madam Chair, if we extend this to December 31st.
Ms. Chavez, did you have a comment in regards to that?
I had just said that the district is in agreement with Mr. Thaird's statement.
All right, so
Okay.
Madam Chair, just a question. Are we confirming that we'll be done by December 31st, or will we have to come back?
Well, let me put in maybe a fly to the ointment here. I think you will remember, board members, this recent December and how there was a flurry of requests for companies to come before us for requests for hearings. There were days when we only had one clerk person there. And what I'm going to be asking in the next few months, and I've had a discussion with not only the clerk of the boards, but also Mr. Pearman, and this will be part of our requests to the governing board, is that we don't let anything sunset on December 31st because of the fact that we don't have enough staff 9 times out of 10 to address whatever needs to be put on the calendar. And I don't know whether it's amenable in this particular case, since we haven't gotten there yet, whether the parties can agree to even November 31st. If that's not realistic, I would like to know, I would like to hear from them.
Madam Chair, thank you very kindly. Much appreciated.
I just had a question and I just want to find out, I think I heard Mr. say it was notice as a modification. Can the clerk confirm how was the public notice? Was it notice as regular or as a modification?
It was noticed as a regular.
Yes, it was noticed as a regular variance. We generally do not extend a short variance. It becomes a regular variance. And that's how it was noticed, because that's the natural progression for noticing.
And Mr. Balakapalan, I assume I know where you're going. I'd rather us adhere to what we noticed
Right.
and make it clean. So there's no ambiguity should someone have a question. Thank you.
On behalf of petitioner, I am not opposed to treating it as a regular. We think we'd still have to make the same findings, and that wouldn't change. And frankly, the increments of progress, even if they aren't required, are still a very good idea. And certainly that won't change our agreement to the conditions. In regards to Madam Chair's comment about the timing, we are not opposed to shortening it somewhat. One thing that we had considered was whether or not to include, and we'd be willing to do this potentially, include a condition that I don't know if this is a normal thing, but includes a condition that has a mandatory comeback date. In other words, we've already been here a couple of times. It occurred to me that the board may say, let's put something on the calendar for, June X or whatever, so we can talk about progress. And if we need to have an extension, then that's a little bit separate from what Mr. Ali was talking about, but it is something that we considered. I think we could live with a little shorter, if we needed to, if we wanted to reduce it by a month or so. But we can talk about that.
Ms. Chavez?
Yeah, I'm only concerned about shortening it because looking at the dates that we have right now, if we took the longest time that we conservative estimates, it would put petitioner's due date to submit their source test approximately October 15th-ish. And then source testing would have to review it. And I don't have somebody from source testing here to tell me how long it would normally take. And so that's gives a month and a half to till end of November. So it could be done, but I just don't have anybody here to tell me what's the usual time for a source test review.
Well, I think it's possible that our engineer member may be able to speak to that. Mr. Balagopalan?
I think we can discuss it in our deliberation. So
yeah.
And I can.
That's what I was referring to.
Just as a comment, I would say, if you're granting as per the notice a regular variance, February to December, it's basically 8 months. So that's within, even though the end date is the end of the year, it doesn't mean they have to come at that date to for a modification. If they need it, they can, typically request it much earlier to do a modification if there was some problems. So I don't think there's any issue per se from what is proposed in the condition to keep the date as is.
Any other discussion, board members?
Well, I was going to, if you're doing, I think you finished with your closing. So the deliberation, I think, based on what we've heard and the testimonies we heard, and the initial issue I had was there was no determination of non-compliance. So I think we got the data now showing preliminarily, even though it's not been reviewed by the source testing group, that they clearly are not able to meet the 5 ppm, in some cases way beyond the 5 ppm, even with the 10% correction, adjustment, significant figures, adjustment factor. So that finding now, I can comfortably say, yes, they're in violation, because we have some evidence that based on preliminary report that they are in violation of the ppm condition of 5 ppm. So, and I think we have heard all the efforts they have taken since the last time when they came before us in July to, if you recall, I think it was prior to that, it was around 6.5 ppm. So they knew they had to make some substantial changes. And I think we saw all the different things that they did to bring it down. And unfortunately, they did not been successful for whatever reason, even though they're identical units and one passed and one doesn't pass, but these things do happen. So I think they have taken all necessary steps to come into compliance, but unfortunately we're not able to. And it doesn't make sense for us to have them put a rental unit, because this unit seems to be much cleaner than a rental unit, even though it's not in compliance. So I think continued operation boiler number 2 until they get the replacement seems prudent instead of getting a requirement, which it's not part of the condition anyway, but I think they did look at alternatives and there are issues with getting a replacement boiler. So I think that I believe I can make all the 6 findings. That the most important one, which is they're in violation now of the permit condition is 23.72, that non-compliance due to beyond the reasonable control. As we heard, they did everything they could. That requiring compliance would be arbitrary, because the emission, even though they in the petition, and that's why I was a little concerned, they said they were just hovering above 5, and I thought, oh, with the rounding, with the it would be, would be okay, but it does not appear from what we saw in Exhibit 16 that's the case. It's significantly higher than even with the rounding you do the allowance given for that. So the emissions are, but it's still insignificant compared to the harm to the petitioner, because we're talking about a few pounds a day at the most of NOx, not so, and the closing with, there wouldn't be that the closing of taking would not be with a corresponding benefit reducing a contaminant, because the harm to the petitioner outweighs the emissions. So they have given consideration, but I think as we've seen, there's nothing else they can do except replace the burners. And we've seen from all the exhibits that they have aggressively pursuing that route to replace the burners and going with a different vendor, and hopefully that they will come into compliance. And I think that's what we said in July, but we are here now, and it is hopefully that they will come into compliance, but they will be continuing to monitor. I don't think they have a SEMS on the NOx, so maybe I didn't see that, but there's no SEMS on the NOx. So what I didn't see, and I think what should have been done, because that's sort of in my opinion, when they failed the test and when it was given that they have to retest, they retested it, they should have submitted the retest so that a determination could be made what the numbers are, and so we can, quantify what the excess emissions are. So right now he's saying 5.12, but they're really looking at the data, it could be much higher. So I think and what the district policy is after when they retest, and if it's clearly exceeding within above the 10%, it's I think the policy says it's a violation. It's not. I think if it's less than 10% on the retest, then it's a case by case how they enforcement policy issues the notice of violation, and that's my understanding anyway. So that I think that's the only thing that I would emphasize, that if they says there's a retest, you submit the retest. So we have the data and as for the requirement. So that everything is all outlined. So beyond that, I think I have really no issues, and I think the conditions as laid out are appropriate. I think personally, I think we should treat it as a regular, because it's the Madam Clerk said it's really beyond. It's expired. It's short variance, and so. I don't think both parties seems agreeable treating it as a regular variance, and I think they should. And the end date of December 31st, it seems reasonable. So I don't think we need to change that. And I think I don't know whether Mr. Pearman, whether we need clarification condition number 3, but we had testimony what she meant in that condition number 3 was after the installation of the burner. So I think, we know that is the case, So unless you want to change a condition number 3, just to clarify that, I think we can accept the conditions as is.
Perfectly fine with accepting the conditions, as is. All right, are we ready to make the motion?
I just wanted to speak to the fact also that it really sounds like they got a lemon here. And through no fault of their own, the fact that they cannot and have been after this manufacturer to own up to it and to do the right thing and replace it and or compensate for it in some way, shape, or form, I think really has added to the fact that they could not come into compliance. And the fact that they have been working with the district, and I commend the district also, staff for working with them as well as the legal department, Ms. Chavez and Mr. Thayard, to try to get this done. It's obvious that there has been quite a bit of effort on both sides, but it all, to me, boils down to the fact that what they had to begin with, it was a failure before it even arrived at their door. So unfortunately for that, but I agree that we can make the 6 findings and would be in favor of it as well. So Mr. Ali, go right ahead.
Yes, the 6 findings, I do believe the 6 findings have indeed been made, and I'd like to entertain a motion to that effect. Right?
Go right ahead.
Thank you very kindly. In the matter of California Steel Industries, Inc., a manufacturer facility who creates and or manufactures flat rolled steel sheet and electric resistance welded steel pipe, case number 4624-23, facility ID 4628. The petitioner is located at 1400 San Bernardino Avenue, Fontana, California, 92335. Move that we grant a regular variance commencing February 21st, 2024, and commencing December 31st, 2024. The petitioner is seeking relief from the following provisions as set forth in the South Coast AQMD rules: 203B, 1100E2B, 1146E1, 1146C1, 2004F1, and 3000C1. The objective is to achieve compliance when boiler ID number D52 satisfies the emissions requirements of AQMD's rules. In addition, petitioner is also desirous of seeking relief from violating permit ID H23-823.7, Section K, Conditions 8, and Section E, Condition 8. The conditions and variance shall be set forth in Exhibit 12. Is there a second?
I'll
Can we have
second
a
it.
second? Okay. All right, any discussion on the motion? Seeing none, let's take a vote. Dr. Abraham, how do you vote?
Aye.
Mr. Pearman,
Aye.
Mr. Balagopalan,
Aye.
Mr. Ali,
Aye.
and I also vote aye. And that's unanimous that it is passed. Thank you very much to Mr. Thayard and your witness and all of the efforts that you have made as well, and working with Ms. Chavez and the AQMD staff, of which I also want to thank. So with that, this matter is closed. Yes?
We still have the fee portion that needs consideration by the board.
Okay, thank you for that reminder. Did anybody want to start the discussion on that?
Yes, I can. Initially, I was thinking, oh, the emissions were like 0.1 tenth of a pound of NOx a day. Maybe we can waive, not to waive the fee, maybe reduce the fee and so forth. But looking at the recent, the test data, the numbers are higher, much higher, so it's not just a fraction of a pound a day, could be a pounds or more, depending on that. So I'm less inclined now to waive the fee unless we have another, they submit a report, get it reviewed by the agency, and then they say, okay, this is the number it is, and then we, but I don't think they want to come back again after that. So I'm less inclined now, after looking at this data in Exhibit C, to grant a waiver. Now, the fee, in a way, is an incentive to get this done sooner, so they don't have to, pay the daily excess emission fee. So I'm not inclined to grant the reduction of fees or waiver of the fees.
Well, any other discussion on that, board members?
Yes, so what would the fees be per day? Just for the record.
I can, the minimum fee they have to pay is about, let me get you the right number, is about $234.00 a day, every day that they are in excess emission daily. They, based on what they provided in the petition, it's 0.12 pounds excess emission, which is not really the case. It's about 42 cents a day. But the rule requires a minimum of, regardless of that, of $234.06 a day. And so, and it adds up, for
So
2 days.
is that the amount that we're looking at that was 141K, I think? Is that, because that was on here,
Yes, if I can clarify briefly, if
Thank
we
you.
based it on the approved source test, or not the approved source test, the source test that was found indeterminate, which is 5.18, the total excess emission was a little over $100, which is a enormous difference from adding the excess emission fee on a daily. However, it's about a $70,000 difference. Our position is still that even if we took a higher number and we did like an averaging of the column, and even if we accounted for the bad runs, the excess emission fee would still be substantially less than $70,000, but we did not do that actual calculation. But the delta between the 5.18 and the minimum fee under 303 is roughly $70,000.
$71,154.24.
Yeah, over the life of the variance.
Correct.
Is that calculated in December?
I just want to add, that's how we normally, all businesses will be treated that way, excess emission based on, whatever you calculate as per the rule 303. And then if it's below the minimum fee, you pay the minimum fee. We have in the past reduced the fees mainly for hardship, mainly for cities and governments and agencies and so forth. I don't think it should. I agree it's a substantial amount of fee, but I think that's what the rule is, and petitioner hasn't shown any hardship in paying the fee at all, and it's not asking relief because of hardship. But and that's the reason. If the numbers were still, the retail was 0.12, I was going to propose maybe 50% of the fee, of the minimum daily fee, just because it's so 0.12 pounds. But unfortunately, the numbers don't indicate that. It's much higher than. So, and that's the reason why at least I wouldn't support waiving the fee, at this time.
Well, let me interject my thoughts here based on the fact that this company has endured a loss of the amount of money that they invested in that second boiler, and the fact that it's never operated correctly, and the fact that that company has gone out of business, and it doesn't look like they're gonna be able to recoup that money. From what source would they be recouping it from? Even if that second company that took over the initial one, that's quite a loss for quite a long time. So I am inclined to at least reduce them. I understand Mr. Balagopalan's position, but I also feel that it has been a hardship for them. Maybe they didn't say it on the actual document, but in listening to what has occurred to them and them trying to battle back, that to me, I give them a lot of credit for doing that, but it's also costing them a lot of money, not only in the cost of the initial equipment, but also in attorney's fees. So I can't ignore that. And I would very much want to see some type of reduction in those fees. Any other comments, board members?
So, Madam Chair, what's your proposal?
I would say a minimum of reducing them by 50%.
Okay.
Well, let me simply state it. Why not just waive the fees?
Well, I think even they aren't asking to waive, they just want to use the lower figure, right?
Yeah, we're not requesting a full waiver of the fees. We would be amenable to a percentage reduction, say even, 50%, or so, but we're not as aggressive as saying we're going to waive the entire fee.
And just to be very candid, I was just joking. I want to break up the monotony.
I thought you were testing me.
Yeah,
Like,
That's a cruel joke.
You're gonna click the
you
heels
wanna
and
go over my skis and request
Exactly.
more than.
no. So I'm perfectly fine with 50%. I believe that's fair.
It's fair.
And what I would ask is that you to get this wrapped up quickly so that we don't have to come back December 31st. We can get this done and we can move on.
Mm-hmm, absolutely. And I think that's what California Steel also wants to do. Any other comments, board members? Okay, so do we need a motion to,
Yeah, I'd like to entertain a motion.
okay, Mr. Ali?
Yes, I would like to entertain a motion that the petitioner shall pay applicable fees at a rate of 50% of 71,000. Well, Mr. Balakapal, why don't you go ahead and why don't you offer the language? No, go right ahead.
I'm not going to go for it, but also the language. I think that, the excess emission fees, as when calculated, shall be no less than 50% of $234.06 for each day on which the excess emission occurred.
I second that motion.
Okay. Any discussion on the motion?
Just one, when we made the first motion, did we adopt Exhibit 12 in its entirely, because we have those paragraphs 12 and 13 that relate to excess emission fees? Did we exclude them from the motion?
No, we did not. It was included in.
So we should just probably, in this motion, correct that. We're also
Yes.
rating paragraph 13 of Exhibit 12, which details when they shall pay the excess emission fees. So that'll be my only amendment, to incorporate paragraph 13 of the prior stipulated findings and decision.
Thank you, Mr. Pearman. Okay, we have a second on the record. Any other discussion on the motion? Seeing none, Mr. Balagopalan, how do you vote?
You know what? No.
Mr. Pearman,
Aye.
Dr. Abraham,
Aye.
Mr. Ali,
Aye.
and I also vote aye. So I think that's a fair statement and a fair decision. So that I know I can live with. And it appears as my board members for the most part can. So with that, again, good luck to you, Mr. Thaird, and to California Steel. And thank you again for coming before the hearing board. Thank you, Ms. Chavez, and your staff, and for all of the work that you did together with California Steel to come to a fair conclusion. Okay,
Thank you.
all right, and that matter is closed, and we can now go to the second matter on the agenda for the consent calendar, which is Torrance Refining Company. Okay. And we have some exhibits to mark. And I'm not going to include the minute order. As was originally marked on here. So the stipulation for the matter to go on consent is number 4. The proposed variance condition number 5, and then number 6 is the proposed findings and decisions. And then we also had a email string, and that will be HB1. Are there any other exhibits that we had, Madam Clerk?
I have no other exhibits, Madam Chair.
Okay. And so that took the place of what we had previously received as Exhibit 6, the proposed amended variance condition for variance, as well as number 7, the proposed findings and decisions, correct?
Correct, there was revised
Right,
Um,
okay,
conditions and the proposed finding. Those are the ones that I'm
were
marking as
replaced,
number 5 and 6.
yes, okay. All right, so with that, in this matter, I'm gonna go ahead and again and let you start, Mr. Balakopalan, since you had the questions and you had the back and forth with
No,
the
I think the only, well, issue I had, leaving Mr. Pearman's name not
right
standing
yes,
out, but I think the only issue I really had was the dates, the short variances for 90 days, and then the initial condition was proposing dates that were beyond that date. So I think the proposed revised condition to make to come when they come back on the 14th of March for the regular hearing, then those conditions were more appropriate to do the testing in April 29th and then transmit the result by June 30th. So because that's within the time frame of the regular variance period. So that's the only condition reason why I sent that comment. But they appropriately revised that condition, so I can live with that. So I have no other comment on that.
Yeah, I also feel that that took care of everything and just put everything in perspective, and the fact that both parties were able to come to agreement on all of that as well. And we will see, I'm sure, Torrance Refining not only come March, but it's a continual situation, especially when we have the alternating conditions. So with that, I think we can make the this is for a modification and a variance of the conditions. So we're not really making a motion on this, I don't believe. We're just accepting the modification variance conditions and the AOC. Is that correct, Madam Chair, Madam Clerk?
Actually, Madam Chair, we do need a motion they're asking to modify a variance, an existing condition. So you do need a motion basically to modify that condition.
Okay, on those conditions.
All right.
Okay, all right. All right, so I'll go ahead and make it. I move that we do accept the modification on the variance and the conditions and the AOC for Torrance Refining Company LLC, case number 6060-20, located at 3700 West 190th Street in Torrance. This is in regards to, as I mentioned before, the modification and the variance, also the equipment. There's no change on the equipment and no change in the applicable rules or the permit conditions. And believe that we will be coming back in, I would believe it was March 14th. Is that correct, Madam Clerk?
That is correct.
Okay. So unless there's any other,
Second,
unless there's any other conditions to that, that is my motion.
Ali seconds the motion.
Thank you. Any other discussion on the motion? Okay, seeing none. How do you vote, Mr. Balagopalan?
I vote yes.
Mr. Pearman?
Yes.
Dr. Abraham?
Aye.
Mr. Ali?
Aye.
And I also vote aye, and so it's unanimous that we will go ahead and accept that, and we will be coming back again on March 14th with this matter. So thank you again, board members, for coming. I wish I could have been there today. I had every intention of being there today until yesterday. So I will see you on the 29th. For sure, God willing. And with that, we are adjourned. And thank you again for coming out. Thank you, Madam Clerk. Is she still there?
Yes.
Oh, thank you.
Down here. Okay.
Okay.
Thanks. Bye-bye.
So we have nothing before the 29th, right?